Michigan Governor Gretchen Whitmer has been trying to shut down the Line 5 pipeline between Canada and the US for a number of months now. And it looked like she was going to be successful. Well, today, the government of Canada invoked a little used treaty from 1977 to stop her. And I'm going to be talking to Dr. Kristen Biezenbos from the University of Calgary about that. So welcome to the interview, Kristen.
Thank you, Mark. I'm happy to be here.
Well, look, maybe can you give us an overview of what this treaty is and explain why the government invoked it?
Sure. So the 1977 Pipeline Transit Treaty was entered into between the United States and Canada immediately after the Arab oil embargo. So it was entered into between the two countries after a period where there was an oil shock when supplies were extremely low, and it caused prices to skyrocket, and it caused energy instability in both countries. So essentially, it was an agreement that, at least as far as the trade of hydrocarbons between the US and Canada, neither country, no public official from either country would ever stop or unreasonably pause the flow of hydrocarbons between the two countries.
And in this particular case, it's about, I think it's just over 500,000 barrels a day, and it supplies refineries in Ontario and Quebec, and it comes from Western Canada. The crude comes from Western Canada, mostly Alberta. And I gather that this would have been a lot of hardships, and the treaty now allows the government of Canada to deal directly with the government of the United States and bypasses Governor Whitmer's lawsuit and her orders. Have I got that right?
That's right.
And so what happens next?
So just to get your viewers up to speed a little bit too, there's some, I think, uncertainty here about the treaty. It's never been invoked before. So the treaty itself, when you read the text of the treaty, it does appear to apply to a situation like this, because we're talking about an existing pipeline where there are, as you said, there's quite a lot of oil that's flowing through Line 5, and in particular, the part of Line 5 that's really the subject of the controversy here, which is the part that goes below the water of the Straits of Mackinac, which is a 6-kilometer wide strait that's between Lake Michigan and Lake Huron. And it's been there since the 1950s. And that segment has never leaked, but it's quite old, and it has been struck by ship anchors before. So there is concern that if something were to happen to the pipeline, there would be a oil spill that would be devastating for the local economies that sort of surround the Straits of Mackinac, including fishing economies, shipping, tourism, all of those things. So it's really a case about the state of Michigan being extraordinarily concerned with the level of risk that they feel that the Straits of Mackinac section of Line 5 poses, where from Canada's perspective, there's never actually been a leak of the Straits of Mackinac section of Line 5, and Enbridge has offered to build a concrete tunnel essentially under the straits and then put a replacement for that segment that's been there since the 1950s. But it would take a very long time to complete that project. And so in the meantime, the section that's been there since the 50s would have to remain there and continue. The flow of oil would have to continue. So the state of Michigan is trying to force the removal of the section of Line 5 under the Straits of Mackinac because of these concerns among local groups, trade groups, indigenous groups about the possibility of an oil spill in the Straits. So in the US, unlike in Canada, an interstate oil pipeline, the siting authority actually does rest with the states. So Michigan is asserting its siting authority over the segment that's under the Straits of Mackinac to have it removed. However, because it is an international pipeline, and because it is, it's a working pipeline, that 1977 treaty, it's been sort of in the background of this case. Again, it's never been invoked, so it wasn't clear whether or not this treaty would save the pipeline. But I think what's happened is that the government of Canada is sufficiently concerned about the possibility that the state of Michigan may be able to force the shutdown of the segment under the Straits of Mackinac. I think that Canada first tried to do this in a way that didn't put too much pressure on the Biden administration by filing what's called an amicus curiae, a friend of the court brief, essentially telling the mediator that was, trying to handle the dispute between Michigan and Enbridge outside of litigation, that the position of the country of Canada is that the treaty does apply. But doing it that way did not directly put pressure on the Biden administration. But now that is what they're doing. I think Michigan says it's not interested in mediation anymore, and seeing the possibility, the potential possibility that Michigan may be able to revoke the easement for that Straits of Mackinac section, the government of Canada has stepped in.
Right, and this is a thorny issue for Biden because Whitmer is part of his sort of Green caucus, or he's the Green group within the Democrats that support him. She's been a very vocal and high-profile supporter. So it's not she's not just going to go away, I guess would be my takeaway from that. So what does this do to the dispute that's already in the courts between Enbridge and the state? Is that halted while the two senior governments engage in negotiations?
That's an interesting question. I think it depends. One of the things that Michigan is arguing in the lawsuit is that even if the treaty does apply, which it argues, it doesn't, but it also is trying to argue that even if the treaty does apply, it's what's called a non-self-executing treaty. So that means that the treaty actually can't be enforced without special legislation passed to enable enforcement of the treaty, and there is no legislation like that. Now, some treaties don't require that. You can just read the treaty and it sort of explains how you would put it into effect. And so Enbridge's position is that it's that kind of treaty. You can just read the treaty and it says no public official will stop the flow of hydrocarbons. It's pretty simple. Don't do that. And if you do, the law can be used to enforce that provision of the treaty. So I'm not sure what the judge is going to do, because there is a question about the validity of the treaties, whether or not it's actually a self-executing treaty or not. I think if I were the judge, I probably would stay the proceedings, though, pending the resolution of the arbitration between the US and Canada.
So now there is the lawsuit, and there is mediation between the state and Enbridge, but is there arbitration now between the government of the United States and the government of Canada, or is there going to be a separate lawsuit to determine the issue around the enforcement or applicability of the treaty? It sounds like there's going to be a lot of procedural wrangling here for a while.
I think that's a reasonable statement. So the treaty it does call for arbitration between the treaty parties, which is the US and Canada. So I think that they would need to begin. I think Canada has signaled that it wishes to begin the arbitration process. So it will need to send an envoy to meet with a US envoy in arbitration. There is, as you say, though, there are jurisdictional issues to figure out. Where will they meet? Where will the mediation be held? What law will be used to determine the outcome? And, some of that is actually in the treaty itself, but the treaty is not particularly long. I don't know if you've had a chance to take a look at it, but it's not a tremendously dense treaty. But, if I were, as I said, if I were the judge, because you would not want to potentially come out with an opinion that would be in conflict with whatever the resolution between the US and Canada is. And we don't even know yet whether the US agrees with Canada that the treaty even applies. So it's just sort of a wait and see now. The ball is in the US's court to see how they'll respond.
So I guess the drama continues, and there are lots of hands to be played here yet. Just a final question, Kristen. When the judge is looking at this, does he or she take into account the fact that the closing of the pipeline might cause significant hardship for consumers and businesses on both sides of the border, or is that an irrelevant point to the judge?
I'm not sure that is a point that has any legal relevance, but it could be something where, when there is a place where a judge has to weigh potential impacts, if there is a legal principle at play where some weighing comes into play, that could be something that the judge would consider.
Any idea on timelines? Might this be resolved in 3 months, 6 months, 12 months?
I have no idea. We haven't actually seen arbitration under this treaty before, so I really have no idea. I wouldn't expect it to be resolved quickly, though. I think 3 months is probably too fast.
Great. Well, Kristen, thank you very much for this. Really appreciate your insights.
You're welcome. Thanks for having me.